Welcome today. It's our great pleasure to have you here with us today and to have our great speakers, David FitzGerald, who I'll introduce everyone in a second, but has a new book out on Refuge beyond reach, on asylum systems around the world, and was the instigator of today's event, and really around that book coming out got us thinking we should do something more broadly on this. You all know my colleague Kathleen Newland and Mary Giovagnoli, who is such a great thinker on this issue, has been inside and outside of government, working on refugee issues, on asylum issues for years. There are a few things, if anyone has been paying attention to the news cycle in the past few days, in other words, not living under a rock, you will have noticed how much asylum matters. It matters in debate going on in this country. It matters for those of you that are from Europe or follow Europe, like my colleague Natalia. This matters enormously to the debates going on in Europe. It matters for those of you following Latin America, right? The debates going on in Latin America are largely debates around labor migration versus protection, right? And asylum systems have come under siege throughout the world at this point. In some tellings, everyone is an asylum seeker who needs protection. In other tellings, everyone is a labor migrant who's trying to game the system in some ways. And in reality, we know that the world is filled with mixed flows today, of people who are legitimately seeking protection, people who are seeking better opportunities economically, and a lot of people who are somewhere in between as well. And our systems haven't really kept up with being able to handle and distinguish and make decisions about this. And this is a huge issue. It's an issue that's driving the national debate. It's an issue over which secretaries of Homeland Security lose their jobs. It is an issue or not. It is an issue that divides national societies, and it's an issue that is ripe for some really deep thinking. Now, David's book goes a little bit beyond this. You're thinking really about why, you're looking historically at this, and you're looking at why it has been so hard to live up to what had been one of the great promises of the late 20th century, the last half of the 20th century, which is this notion, these norms and international law and national laws we built around protection, right? The notion that countries actually owe people protection who are fleeing from persecution, and why it has been so hard to live up to that. But we will dive into these topics today. I'm Andrew Seeley. I'm president of the Migration Policy Institute. You are at the Migration Policy Institute, by the way. This is sort of like when you get on the airplane and they say, this is the flight to Denver. If you meant to be somewhere else, this is your chance to get up and go. You can tweet questions at Migration Policy. You can use the hashtag MPI Discuss. Please tweet for those who are tweeters. And you can email us questions at events@migrationpolicy.org. We welcome all of you who are joining us remotely. We will take a lot of questions from people who are here after the panel discussion, but we also welcome questions from people who are watching the live stream, and we're very pleased you're with us. You can email us, you can tweet at us, Migration Policy, or you can use the hashtag MPI Discuss, and we'll try and catch this as much as possible. David FitzGerald and I met, Scott FitzGerald and I met, I think about 20 years ago, I think exactly 20 years ago, probably, at UCSD, and we were actually thinking about many of the same issues. In perhaps more preliminary form in our life, we were graduate students at UCSD, both doing our masters and both went on to do other graduate work later. He is now the Theodore Gildred Chair in U.S.-Mexico Relations, U.S.-Mexico Relations Professor of Sociology, and co-director of the Center for Comparative Immigration Studies at the University of California, San Diego. His research analyzes policies regulating migration and asylum in countries of origin, transit, and destination. And his new book, Refuge Beyond Reach, which we will flash again at you, Refuge Beyond Reach, is available on Amazon, is available at Barnes & Noble, and at your independent bookstores, by the way. Analyzes how governments in North America, the European Union, and Australia try to keep asylum seekers from reaching their territories. His previous books include Culling the Masses, The Democratic Origins of Racist Immigration Policy in the Americas, which won the American Sociological Association's Distinguished Scholarly Book Award, and Nation of Immigrants, How Mexico Manages Its Migration, which I believe was also the topic of your dissertation way back when. He's been a visiting professor and visiting researcher at the University of Melbourne Law School, University of Paris, University of Guadalajara, in El Colegio Michoacán. And great to have you with us, David. So good. Why don't you start off and give us a few preliminary remarks, and we will then move from there. We'll go to Mary and to Kathleen.
Sure. Well, thanks very much, Andrew, and thanks to the team here at MPI. I'm sorry that I've almost lost my voice shouting in the wilderness about these issues, but I will rally today once more into the breach. I was in Tijuana looking into the U.S. on Sunday, and usually when we think about border control, migration control, we think about these very obvious kinds of infrastructure, of stories that are easy to tell about control of people who would move across borders, such as these kinds of fortifications where I live. But there are all kinds of techniques that governments use to keep would-be migrants, including would-be asylum seekers, hundreds, even thousands of kilometers away from the national territory. So what I set out to do in this book project is to make visible a system of what the late R.S.T. Zolberg called remote control. And remote control is nothing new, whether it's deliberately targeting asylum seekers, other kinds of refugees, or simply unwanted migrants of many different kinds. We know in this country the story of the St. Louis, a ship of nearly 1,000 German Jewish refugees who tried to arrive in Cuba, were denied landing in Cuba, tried to land in the U.S., were intercepted by the U.S. Coast Guard within sight of the lights of Miami, rejected by Canada, rejected by other Latin American countries, eventually returned to Europe, where about a quarter of the passengers were eventually murdered in the Holocaust. Maybe less well known is an application made a couple of years later by the family of a German spice merchant who was living in the Netherlands. You can see here on this, this document, the final name in the far left is his daughter, Anne. The application for a U.S. visa was never successful, and later Mr. Frank's two daughters and wife also died in the Holocaust. So this system of keeping refugees at arm's length has been with us for a very long time. And it's the failure of the Allied countries to protect German Jewry and from the Holocaust, as well as the Cold War politics, some probably also forgotten incidents of people who were trying to defect to the U.S., of being openly refouled into the arms of their persecutors, that led to things like the I-589 form, which are still with us today. So in the story, I recount this history. But moving up to the present day, we are often asked, why is it that someone who has a legitimate case as a refugee, who really is a refugee, who really is fleeing persecution, why would such a person ever travel illegally? Why would such a person maybe come to the border of the US or Europe or Australia without a visa and come in that way, having broken maybe a number of countries' migration laws across the way? I think it's a legitimate question. It's a question that I try to answer seriously to show that there's a reason why. How could you reach a place of sanctuary, broadly speaking, including asylum, if you are a refugee? Well, despite all of the attention to refugee resettlement programs, which are important, in any given year, even before the Trump administration's slashes to the program in the US, less than 1% of the world's refugees were ever resettled through one of those programs, which are in 30-odd countries. Many countries don't allow any form of diplomatic asylum, where someone goes to an embassy and asks for asylum, and no country is that a real option unless you're maybe a very high-profile dissident. For no one else is that an option. There are a handful of programs. Claire Higgins has written about some of these programs where it's possible for people to apply in country for asylum, or at least in the past there have been such programs. In all cases, they're very small. They have inherent problems, such as the fact that if you line up outside an embassy to apply for asylum, you're openly identifying yourself as a dissident to the secret police, for example. So that's not really an option either. And that leaves you with the option of territorial asylum, of reaching a territory of a country like the US where you ask for asylum. And the basic principle that undergirds the system is the principle of non-refoulement, that you will not be returned into the hands of your persecutor if you meet the statutory definition of a refugee. And not all countries have signed the UN Refugee Convention that's enshrined this principle into law, but most of them, including the US, have signed that and or the 67 protocol. And there's an even stronger version of non-refoulement in some ways in the Convention Against Torture that prohibits the return of people who will be tortured regardless of why they would be tortured. The US and even more countries, 162 countries, are party to that convention. So what do governments do? Well, they evade their obligations. They evade the spirit of human rights and long-distance humanitarianism that motivated those laws by manipulating territory in a couple of different ways. The first is to push out border control, as I said, using various techniques of remote control in the kind of an extra territorialization phase, pushing the border control out. At the same time, the distinctions about where the border is are made down to the meter, down to the centimeter, in this hyper-territorialized differentiation between whether or not you are inside the US or outside the US. And this is not just the US phenomenon, but I'll talk more about the US since we're here. And when I mean a hyper-territorialization, I really am talking about a matter of centimeters. These are sort of like dot bots, if you're familiar with a highway construction system, but these are the raised little discs that you can find in many different ports of entry between Mexico and the US. And we know that in many cases now that US agents or private security guards acting on behalf of the US government are putting their boots right on this line between the US and Mexico to keep someone from literally being able to stick their toe into US territory and to be able to avail themselves of rights of personhood that you get by virtue of being in US territory, regardless of your legal status. So what is new that's different from efforts to keep Jews away from the Americas and Palestine? What's new now is that there's this modern system of remote control, and it's a truly global system. There's what I call in the book an architecture of repulsion, and I use deliberately medieval metaphors to highlight the different elements of the system, and I'll go through what I mean by these different elements of cages and domes and moats and so forth. All of these pieces work together as a system. The interception at sea in the moat, that doesn't work unless there's some kind of place with special, more restrictive rules. And so I show the interlocking character of these structures, and also the way that ideas about best practices, or depending on your political point of view, perhaps worst practices, circulate among the governments of the rich democracies of the global north. There's also a circulation of funding to build up the coercive capacity of buffer states like Mexico or Indonesia or Morocco, as well as all kinds of training, provision of materiel, and so forth. Okay, let me spend just a few minutes talking about some examples of what I mean by these specific strategies of remote control. And the first is to cage people up, either in their country of origin or in another country before they could reach a place like the US. And here the architecture of repulsion is part and parcel of the architecture of protection. The same camps that provide vital services, vital security, even for refugees, also serve the function of keeping them bottled up in mostly the poor and developing countries around the world, where more than 8 out of 10 of the world's refugees are. Australia has its own idiosyncratic offshore processing system, for example, which is unusual because under the Pacific solution, people who arrive by sea without visas, so-called irregular maritime arrivals, are sent to the Republic of Nauru, Manus Island, for processing. What's unusual is that they have not passed through those territories to get to Australia. And we also know that of those who have gone through refugee status determination in those countries, the vast majority are refugees. Everyone agrees they're refugees, and yet under the current system, they're not allowed to resettle in Australia. A handful have ended up in the US. Okay, then there's also a dome, and really this aerial dome in the air passenger system is the most important piece of remote control. It's the part that's hardest to see because it takes place behind closed doors. And we might take it for granted that there's a system of visas where you need a visa to travel to many countries, but historically that's pretty new. That's something that we've only seen in the last 100 years or so. We also know that the most restricted nationalities in the world, the nationalities that are most likely to require a visa in advance to travel, are all the major asylum-producing countries. And this is a system that's in effect carried out by airline personnel rather than the governments themselves. There are too many passengers involved. In the US, there's an idiosyncratic pre-clearance system. 15% of air arrivals in the US have been pre-cleared abroad. What's interesting here is that it's impossible to apply for asylum at those airports abroad, whether they're in Canada or Abu Dhabi or some other place. So the US exercises control and turns on whether or not it prosecutes people for smuggling, for example, in those spaces, but does not allow for asylum. I don't have time to go into depth about that system, but there's a lot of detail there. Then there's the moat, maritime interceptions. The scale of maritime interceptions, which include an unknown number of people who would be seeking refuge, but it would be in the many tens of thousands. The scale is quite large. Since this began as a concentrated program during the Reagan administration, the US Coast Guard has intercepted more than a quarter of a million people, mostly Haitian and Cuban nationals, but also from many other countries. And what originally was stated as a policy of never refouling people who met the refugee standard, who were intercepted by the US government and international waters under the Reagan administration, was changed in 1992 under the first Bush administration to allow that kind of refoulement. And that was upheld by the US Supreme Court. I don't know anybody in the legal business who likes that decision, but it remains the law in the US. By contrast, in Europe, the Strasbourg Court, the European Court of Human Rights, has said that member states who intercept people at sea have effective jurisdiction over them and have to abide by the obligation of non-refoulement. The solution in Italy has been to pay the so-called Libyan Coast Guard, i.e. militias, the people, literally the same people who just a few months ago were smuggling migrants and asylum seekers to detain them, often in horrific conditions. There are videos, if you go to Google on CNN, videos of these militias openly torturing asylum seekers in Libya. When I say torture, I don't mean that in any kind of narrow sense of the term. I mean in the most classic, harsh sense of the term. So that has been the cynical Libyan solution. Turning to our southern border, again, it's nothing new for the US to use Mexico as a buffer state. The claim is often made that Mexico is doing nothing to prevent people in transit from reaching the US. Since the early 1980s, there have been camps set up in Mexico. They're no longer there, but specifically to bottle up Central Americans, specifically Guatemalans, to a lesser extent, Salvadorans. And in the book, I talk about a lot of other policies that have been forgotten, about effective policies of putting pressure on the Mexican government to slap visa restrictions on Central Americans, to conduct internal security patrols and migration control patrols, and to even systematically prevent Central Americans from reaching the northern border. The scale of buffering is huge. Since 1990, the Mexican government has deported more than 3 million Central Americans. And in the graph here, you can see in blue deportations of the three main nationalities, Guatemalans, Salvadorans, and Hondurans, which were carried out by Mexico, and in red by the US. And you can see that for most of these years, the Mexican government has been doing the lion's share of these deportations. And finally, the last strategy that I discuss is the idea of a Barbican. If you haven't thought about medieval castle construction in a while, which is often an issue with American audiences, a Barbican is simply a gatehouse or a space outside the castle proper. And I use this metaphor to talk about a number of different techniques of trying to create special, more restrictive rules at the margins of the territory, claiming that really the national law, such as U.S. law, doesn't apply in the same way in those spaces. Think for example, the Guantanamo Naval Station in Cuba, or what the Trump administration attempted to do by saying, well, if you crossed the southern border to ask for asylum, that there were special rules along the southern border. The courts enjoined that. In many countries, in Europe, for example, there's an effort to restrict the rights of asylum seekers in international airport transit zones. So there's a whole range of these kinds of techniques. And we'll leave you with this, which is that I look at the way that the United States, Canada, Australia, and the countries of the European Union, since the 1930s up until July 1st of last year, have tried to keep asylum seekers at an arm's length. And most of these policies work in large part because they're conducted in secrecy, and they're difficult to see. And one of the challenges for journalists, for the advocacy community, for elements within the government who are concerned with human rights and with long-distance humanitarianism is how to highlight the consequences of this system. Sometimes the consequences are obvious if there's a dead body that washes up on the beach. The tragic case of Alan Kurdi, the 3-year-old Syrian boy, for example. But most of the time, there is no visible harm to an individual person that's easy to write about, that's easy to photograph. And I think it's a challenge to show what the effects are of this policy, even when the effects are not easily visible. So thanks very much, and I look forward to the next commentators.
It was great. That was very clear, and I'm looking forward to the book arriving hopefully on Friday, actually, so good. Highly recommended, by the way. Mary Giovagnoli is the director of the Refugee Council USA, a longtime friend of MPI as well. She has more than 20 years of experience in refugee, asylum, and immigration issues. She most recently was the senior director of public policy at NAFSA, but she also was the deputy assistant secretary for policy for immigration policy at DHS under the Obama administration from 2015 to 2017. She began her legal career as a Department of Justice honors attorney with the INS, later joining, and I should recognize here Doris Meisner, my colleague and senior fellow, former director of INS
My
as
first
well.
boss.
First boss many years ago. And went on when DHS was created also to work with similar roles at DHS for many years. When I met Mary a few years ago, you actually were either at the National Immigration Forum, or I think you actually were running at that point the Immigration Policy Center, the American Immigration Council. So great to have you here with us, and issues that you care deeply about and know extraordinary amount of. So how do you see this?
Well, thank you to David and to MPI for creating the opportunity for this conversation. And I want to try to frame things in the context of control that David, I think, has sort of set up for us so nicely, and look at some of the very particular and immediate things that have been happening in the last couple of years in both the refugee resettlement and asylum space, because it is not only important in its own right, but I think it's a harbinger of things to come. I mean, there's no doubt that there is a major crisis in refugee resettlement and asylum within the U.S. The last 2 years have been devastating, but they've actually been 2 years that are really focused on the reduction of all kinds of immigration, both undocumented immigration and legal immigration. Sort of in a by hook or by crook, we want to turn back the clock to some imaginary time when the right people came in the right way with the right skills, and sort of like really kind of trying to rewrite history and the narrative about immigration in this country. But because I think that much of that fundamentally does go to issues of control. How do we control our system? How do we manage the border? All of these kinds of things. It really becomes a situation where the messier the immigration law is, or the more complicated it is, the more likely it is to come under attack. So in that case, given the unpredictable nature of asylum and even of refugee crises, it becomes a real target for the type of control measures that David was talking about. So I'm going to give you just a real quick snapshot of some of the impact of the Trump administration's policies in the last 2 years, and then just some thoughts on how to frame that up in the guise of the notion of control and the way it's almost co-opting the idea of humanitarian responses in the U.S. So very quick. As I'm sure most of you know, the president has the authority to issue a presidential determination annually that sets the refugee admission goals for the year. It has averaged since 1980 about 95,000 people. The average admission rate has been closer to 80,000. We've had ups and downs over the years, but towards the end of the Obama administration, it was 85,000 in 2016 and a whopping for us 110,000 refugee admissions in 2017. That was the target. Of course, in the beginning of 2017, when the Trump administration took office, one of the first things that the president did in conjunction with the Muslim ban executive order was to slash refugee admissions for fiscal year 2017 to 50,000. And subsequently, a number of other limits that we can go into more detail about were imposed on refugees, particularly both nationality bans and very suspect security reviews, but really trying to drill down the number of refugees who could come into the country. In fiscal year 2018, the first year that the administration controlled the process completely, the annual admission number was set at 45,000 refugees. One of the lowest, if not the lowest, ever to that time. And unfortunately, we only admitted about 22,485. So we really barely made half of the number of refugees that had been set out as a pledge. The subsequent year, fiscal year 2019, our goal is 30,000 refugees, and thus far at the 12-year mark, we've managed to get to about 12,100. So we're not even at the midway point of admitting refugees. And we'll have to see what happens in the coming months if those numbers come up. But we very much are worried that we won't even make that very meager number. Now, asylum, it's a very different kind of story, and you have to look at the numbers in different ways. I mean, on just sort of the raw face of it, asylum applications, I just lost my page for a minute, but asylum applications are up significantly. But last year, the affirmative asylum grants were about 16,000, and the grants in immigration court were about 10,000. So roughly 26,000 people were awarded asylum last year. But you really can't look at that number to sort of figure out what's going on in the asylum sphere for a variety of reasons. One of them is that the backlog for asylum applications has become incredibly dramatic. There were, at the end of 2015, about 109,000 cases pending. And at the end of 2017, there were about 280,500 cases pending. Much of that comes from applications for asylum that have occurred in the last couple of years. But also, much of it comes from the fact that there is a growing crisis in Central America, in Venezuela, that is pushing the numbers up. But even those numbers themselves aren't that reflective of what's happening, because much of the real, I guess you'd say, activity in the asylum sphere is not being devoted to asylum claims per se, but to the adjudication of credible fear claims on the border. And even in 2015, when I was in government, one of the first things that people in the asylum program said to me was, we are dying under the weight of the credible fear process, because we can't get to our asylum applications because we're being put on so many rotations and details and having to pull more and more officers to the border. And the reason that that is in and of itself a difficult issue is that credible fear is a component of a broader enforcement strategy called expedited removal, which is an accelerated removal process that has built into it a recognition, and I think this fits very nicely with David's sort of analysis, of the need to still provide an opportunity for protection. And what has happened over the course of many years is that when people talk about, say, asylum loopholes, what they're really talking about is the fact that they can't use the enforcement scheme they would like to use to expeditiously remove people, because gosh darn it, those laws and those international treaties mean that we still have to provide some kind of access to people to actually apply for asylum. And the grant rate in between October 2017 and June 2018 for credible fear screenings, they conducted 72,000, the Asylum Office conducted 72,000 credible fear screenings. They found 55,000 or so of those folks to have credible fear. Not surprisingly, a lot of those folks come from the Northern Triangle. And not surprisingly, that has made the administration very, very anxious to try to find ways to curtail that flow of migrants. It simply doesn't kind of comport with the idea that we are in control of the system if we have all of these people who are seeking access. Even if they're coming to the border, even if they're presenting themselves, even if they're not being intercepted, but actually affirmatively saying, I need asylum, it undermines this notion of control, I think, that the Trump administration has wanted to sort of lay out as their primary goal in immigration. But to sort of put a finer point on it, in the case of refugees, we've really seen a systematic reduction, not only in the number of refugees admitted, but in turn, a vicious cycle that by lowering the number of refugees, the administration is then able to turn around the next year and say, well, we didn't even make that number, so we're going to do a much more realistic number for 2019. And so we only got to 22,000 in fiscal year 2018. Well, we'll shoot for 30,000 in fiscal year 2019. Now, some of that is because of, difficulties with background checks and things like that. But it also sets up this very powerful framework for the administration to be able to justify smaller and smaller refugee admissions, arguing that we can only do so much. And what it then turns around and does is affect the capacity for the United States to resettle immigrants. So in fact, at the direction of the State Department, since the beginning of 2017, we've lost about a third of our refugee resettlement sites. Now, many of those sites still exist and are doing other services for refugees and other folks, but in terms of the immediate reception and placement grants that are awarded to the 9 national resettlement agencies, about 100 sites have lost that ability all around the country. And as that capacity goes down, that then becomes another piece of the circle. Well, we don't have as much capacity, so we can't bring in as many people. And you can imagine this sort of spiraling down to an almost zero number. And in fact, there are other indications that there are some in the administration who would like to do exactly that, including trying to move the functions of Population, Refugee, and Migration Division and State Department into USAID, and alter even the way that refugee admissions are determined. For asylum, the government's response has been, much more complex, because asylum seekers, they basically have more rights. They're here, and so they're able to leverage far more legal means for challenging decisions that are made. And in fact, most of the items that automatically come up when you're talking about the impact on asylum, altering the legal standards of what defines persecution for domestic violence and other victims of violence, the attempts, as David described, to limit where and how people can apply for asylum, the national emergency, the Remain in Mexico program that's been recently announced and even more recently enjoined. All of those things have been efforts to contain loopholes in the administration's work, to keep people from being able to make the claim for asylum, and to do so in a way that really then turns around and puts the pressure on Congress to address the problems by fixing the law. And so I think one of the most insidious things that the administration has done in this context is really to attempt to pit refugee admissions and asylum adjudications against each other. The administration has blamed the reduction in refugee numbers on the increase in asylum seekers, although these are very different systems, and while some of the same adjudicators are often involved, they are two different streams of admitting people and addressing the situations that are needed. And always talks about asylum as the problem at the border, not recognizing this crucial distinction that what we're talking about is really that preliminary adjudication of determining whether or not someone has fear. And with refugees, because you can't with refugees, you can control the number because the president has so much authority. With asylum seekers, you can't. So what you've seen is sort of this dual strategy of doing everything within the executive branch to slash the number of refugee admissions as much as possible, blame it on asylum seekers, and then turn around to Congress and say, these are the reasons why we need to change our laws so that we can have a more robust humanitarian protection system. And so it's really tautological, but there it is. It's a circle of arguments that keep pointing towards reducing and reducing and reducing our commitments. So I think that what is really happening then is that the administration is framing the questions in a way that says, rather than how do we ensure that people who need our protection receive it, the administration has really reframed the question to be about how do we ensure that people don't game the system. It starts with an assumption that the people who are attempting to seek access to the U.S. and are attempting to seek protection their claims are fraudulent. It starts with that assumption. And anytime you start with that assumption, you are going to push the system into a space where the benefit of the doubt, discretion, issues of managing, I think, individual adjudication and individual assessment of a particular person's needs is going to come up against much more sort of hard and fast rules. Thus, the wall, thus the the national emergency, everything that sort of says there is a bright line here and we're going to draw it, and we're going to draw it in such a way that it really limits access, I think, as David has pointed out. So these aren't physical, but they create the physical barriers in a lot of ways that make it impossible for people to truly access protection in the United States right now. And I will just leave it at that for the moment and look for more discussion.
Thank you, Mary. That's great. Kathleen Newland, great pleasure to turn it over to her now. My colleague at MPI, senior fellow here at MPI, and one of the founders of Migration Policy Institute. She is an expert on the relationship between migration and development, on the governance of international migration, as well as on refugee protection around the world. She was the founding director of the International Diaspora Engagement Alliance. She was a fellow and a senior fellow at the Carnegie Endowment, and co-director of the migration program there, which became MPI. And she sits on boards as diverse as the International Rescue Committee, KIND, the Foundation for the Hague Process on Migrants and Refugees, and the USA for UNHCR, and the Simpson Center. Most importantly for today's discussion, Kathleen has been one of the leading non-governmental experts involved in the Global Compact on Migration as it was going from its formative stages to its coming to reality in the past few months. And Kathleen, how does this look at a global level? How did this figure into the discussions of the Global Compact, as well as the Global Compact on Refugees, of course, and tell us
Sure,
what's
yes.
going on.
Well, thank you, Andrew, and let me join you in welcoming David and Mary and all of you to MPI. It's a great discussion so far, and I'm looking forward to your inputs. 2018 was hoped to be a sort of turning point in the governance of international migration. And I'm sure that you're all aware that from 2016 through the end of last year, states were engaged in a process of negotiating a global compact on migration and cooperating with UNHCR to come up with a global compact on refugees. So I'm going to talk mostly about the refugee compact in the context of this discussion, although also some sort of overlaps and gaps between the two compacts. The genesis of the two compacts, as I'm sure it's obvious to all of you, was in some very high-profile refugee flows over the course of sort of the second decade of the century, from Syria, from Burma, many others, as well as some greater attention to these very protracted refugee situations originating from countries like Somalia, Sudan, and many others, which had seen, in some cases, a third generation being born into refugee camps and communities. At the same time, particularly 2015 and 16, I should say, of the sort of refugees in the world, 86% of them are hosted in low and middle income countries. But in the middle of this decade, we saw a number of highly developed countries experiencing large-scale arrivals of asylum seekers, which their political classes perceived or chose to portray as crises. That situation really, it was the sort of direct skin in the game on the part of the major donor countries, which led to a summit in the United Nations in September 2016 on large movements of refugees and migrants. Produced a document called the New York Declaration, which called for these two global compacts to be negotiated. And it's interesting the way that process evolved, because the 2016 summit was very focused on large movements of refugees and migrants. It would never have happened without the 2015 crisis in the Mediterranean, in my view. But it quickly escaped those confines and became a discussion about the refugee and migrant situation worldwide. The expectation from that 2016 summit was a bit cloudy. Developing countries and the host countries of refugees were insistent that there should be a compact on refugees and migrants because of the prevalence of mixed flows in many of these contexts. The developed countries wanted the focus to be on asylum seekers and refugees, and would have been quite content to have the summit produce a global compact on refugees and leave the more difficult subject of migrants aside for later or never treatment. However, this was in the General Assembly, majority vote, so the views of developing countries had to be taken into account. And the solution was to split the refugee compact from the migration compact. And an interesting difference in the process, the refugee compact was left very firmly in the hands of UNHCR. They came to that summit with a global compact on refugees all ready to go, expecting that it would be adopted then and there in September 2016. But the insistence on the migration compact held it up as developing countries insisted that these two compacts had to proceed side by side. So UNHCR very firmly in control of the refugee compact. The migration compact was a state-led negotiation. Now you can imagine on migration the very difficult process of reconciling the views of origin countries, destination countries, countries of transit, countries of first asylum for refugees who were mixed with non-refugees. It was a very difficult process, and I think it's absolutely remarkable that we did, in fact, end up with a compact that was endorsed in the General Assembly by a vote of 152 to 5. Of course, the US was the sort of leader of the no vote camp. But as I said, I want to talk primarily about the refugee compact, which was much less controversial. In part, it was less controversial because it is in many ways a very conservative document. It makes no attempt to extend refugee law to bring new groups into the coverage of the Refugee Convention. As I said, the process was in the hands of UNHCR, and one of its primary concerns was not to endanger the 1951 Convention relating to the status of refugees, not to reopen that, not to erode the protections of the Convention, limited as they are in many ways. So there were no new grounds for protection. One of the hottest topics in these processes was people forced to leave their homes as a result of the impact of climate change. Nothing about it in the Refugee Convention, or very, very slight mention. Although there is a section in the Migration Compact on people moving as a result of the impact of natural disasters or the effects of climate change. As I said, quite a conservative document in one way, but innovative in others. In what ways is the Global Compact on Refugees innovative? Well, the main way is that it turns the attention of the international community to the countries hosting refugees. The primary purpose of the Refugee Compact is responsibility sharing, is international solidarity for those countries that are hosting 86% of the world's refugees, low and middle income countries. And in what ways does it go about in doing this? It puts a great deal of emphasis on support, on financial support for those countries. I think one of the most significant outcomes of the process was, which started before the Refugee Convention was adopted and was very central to what's called the Comprehensive Refugee Response Framework, which is the sort of framework and the mechanism for supporting host countries. And one of the most significant outcomes is a deep involvement by the World Bank in the Comprehensive Refugee Response Framework. So you have new sources of finance, new thinking about ways to support host countries, and not just through the conventional humanitarian support coming from the donor countries, but the use of things like trade pacts, which would give preferential treatment to goods coming from countries that are hosting refugees, particularly from special economic zones in which refugees are allowed to work. In many of the first one being a compact with Jordan that set up that situation. Otherwise, in Jordan, refugees have very limited access to legal permission to work. And that is one of the other major emphases of the Refugee Compact in the Comprehensive Refugee Response Framework, is an emphasis on self-reliance for refugees. That rather than being dependent on essentially sort of charitable negotiations from the international community, that refugees would be giving much more scope to work, to support themselves, and to have access to other channels than refugee resettlement to find third country solutions. So the compact is looking for an expansion of scholarships for refugees who, the data on the number of refugees who actually are able to proceed beyond primary school is dire, the drop off to secondary and then to the vanishing point when it gets to tertiary education. So an emphasis on more opportunities for education, greater access to legal work, and these under the sort of rubric of complementary pathways, complementary, that is, to refugee protection, which, as Mary has explained, has taken a dramatic dive in the United States. And while other countries have increased refugee resettlement somewhat, nowhere near enough to compensate for the drop in the US program, which was larger than all other programs combined until 2017. Let me just say a word about areas that were identified in the compact as being in particular need of support. One is the ability to receive refugees, the reception conditions, including things like registration, so that to reduce some of the sort of chaos in the initial stages of refugee arrivals, meeting the needs and supporting the host communities, and encouraging local ownership of the arrangements for hosting refugees, involving municipal authorities, involving local NGOs, diverting the money away from international organizations and international NGOs to the local level, and the governments, not only the governments of the hosting countries, but at really the local to the local communities. Some of the weaknesses, I think, are connected to that. You know, the question about what really is the capacity of national authorities and local authorities to perform these functions that they're being supposedly supported to perform, but the question of whether that support will be enough is, of course, looming over these discussions. There's also a question about the willingness of national authorities to do this. If you look at a country like Kenya, which has for 40 years been hosting Somali refugees at the same time that they're being attacked by terrorist group from Somalia, you know, can understand that there's a bit of reluctance to be more welcoming to Somali refugees, as well as concerns about having refugees stay permanently in the country. For some countries like Lebanon, like Jordan, that's really an existential threat given the high proportion of refugees among their current residents. I already mentioned the failure to deal with the sort of the elephant in the room, which is people moving as a result of climate change. It's just too scary to, you know, contemplate the potential numbers, the movements we're already seeing. The question of should these people are definitely in need of protection. Are they in need of refugee protection? What other kinds of protections are available for them, if not refugee protection? That, I think, is really the major weakness of the intersection of these two compacts, is that there really isn't a solution of how countries should deal with very large mixed flows, which are not exclusively the result of climate change, but take a situation like Venezuela, which Andrew is doing so much work on at the moment. You know, clearly people are fleeing Venezuela because of a well-founded fear of persecution. Others are fleeing Venezuela because of economic collapse, probably the majority. And when you have an economic collapse that is politically caused, where does that leave the question of persecution and refugee status? The Trump administration stayed in the Global Compact for Refugees process until the very end, unlike the Migration Compact, which they pulled out of quite close to the beginning, December 17, just before the negotiations even started. But they stayed in the Refugee Compact, and you can understand the logic of that, given that the compact was meant to increase the capacity of host countries to keep refugees, to put it sort of crudely. You would think that that would be an interest of this administration, and some in the administration concluded that it was, and engineered quite a few compromises that made their way into the compact, only to pull out really at the last minute. Not only did the U.S. delegation vote against endorsement of the compact in the General Assembly last December, but it insisted on a roll call vote, a recorded roll call vote, unlike the usual procedure in the General Assembly of acclamation. So they were taking names. And I think it's a very disturbing statement that they have refused to endorse a compact whose primary focus is responsibility sharing, is international solidarity, and despite its flaws, has a real potential to increase the well-being of refugee populations and the stability of host countries.
Thank you, Kathleen.
Thank you.
Great. I'm tempted to go back to all of you because it would be a great conversation, but I'm also mindful there's a lot of questions out here. So why don't we turn to the audience for your questions, and you can all add in things that I know you'd like to respond to each other. Those in the room, there's a simple way: raise your hand. Those who are, however, remotely watching this can either send us emails to events@migrationpolicy.org. We have a couple of questions already that have come in that way, or you can tweet questions at Migration Policy or use the hashtag MPI Discuss. So we'll open up the floor here. The hand up here, and there's a hand here, and I think I saw a hand moving here. We'll take a round of questions. So, and if you could identify yourself. And then,
Josh Good with Ethics and Public Policy Center. Kathleen, this is a question for you. I wondered if you might just comment on how you see the present wave of European populism impacting some of the trends that you were describing, with thinking especially about Hungary and Italy and Spain and Poland and elections that are forthcoming. Would you comment on how that perhaps is likely to affect numbers and how those numbers of Iraqi and Syrian migrants might impact those elections?
Sure.
let's do a quick round
Okay.
here, and then there's a hand here. We'll do 3 or 4, and then come back to the panel.
Thank you, and this is a question for Kathleen, but also the other members of the panel. My name is Emiliano Alessandri. I was the migration focal point for the OAC in Vienna until recently. And I have a question about mixed flows, and not only flows that include both migrants, labor migrants, and refugees, but people that are actually in between or in gray zones, coming from countries that lack, the rule of law or they're failing states, and whether you think these two compacts help sort of address these situations around the country, as you commented already, because they separate migration issues from refugee issues, can actually act as an additional obstacle for a good discussion about this. And we tried as OSCE Secretariat to promote this discussion, and we faced, of course, a lot of pushback from member states, but not only member states, but also from the agencies, I have to say, very politely, including UNHCR and IOM, because of course they're very much aware of their mandates, their different mandates, and from a UNHCR perspective, it was very legitimate to try to protect the 1951 Convention and to avoid any sort of discussion about how to revisit that and expand that or change that. So if you can comment on these situations in between, if anybody's taking this discussion forward, not only from a legal standpoint, but also from a political and intellectual standpoint. Thank you.
And I think there was a hand over here, or if not, right there.
Hi, thank you very much for that discussion. My question was primarily directed at Professor FitzGerald. I wanted to point to the comments by President Trump about closing access to asylum on the border, and how, if you could give an opinion on how that is reminiscent of Australia's approach, and is the Australian model able to be fully implemented and replicated here?
And before we go back to the panel, we'll do another round in a minute. Before we go back to the panel, let me give you one question from Twitter. The first one came in, which is if anyone wants to comment on the number of Iraqi refugees waiting in Turkey since 2013, 2014, 2015, and what is their fate? Okay, let's go back to Kathleen. Why don't we start with you?
Okay, well, obviously, and thank you for those very good questions all. In terms of how European populism will affect the numbers of arrivals and the responses, it obviously does have an effect, and the numbers of arrivals since 2015 have gone way, way down, as I'm sure you know. I don't think that that is so much a question of people having heard the populist antipathy to arrivals, but more arrangements, the EU-Turkey agreement, perhaps some of the attempts to sort of bottle up people in North Africa. But I think one of the main effects of the populist responses, particularly from Italy, has been a sort of squeezing the balloon. You know, first you had the arrivals in the Eastern Mediterranean into Greece go down. After that, arrivals in Italy became the largest source, although they were not by and large the same people. You know, the flows into Greece were primarily refugees from Syria, Afghanistan, people coming sort of through Turkey in that direction, whereas the arrivals from Italy were primarily North African, Sub-Saharan African. But when the populist government was elected in Italy, started refusing landing rights to refugee rescue boats, beefing up the interception in the Mediterranean, what you saw was a diversion to Spain. And that, I think, in maritime migration, which I don't know if we have any copies or flyers out of a book that we did on that 2 years ago, this phenomenon with maritime migration of sort of squeezing the balloon is a pretty common one. But I think the populist responses have justified those attempts to do the kind of things that David has talked about, and you may want to come on this as well, David, to support you know, the building of walls and fences through the Balkans, the very tough attitude toward maritime migration of the Italians, the pretty tough but much quieter responses of the French, and pressure along the whole chain. On the question of how thank you very much for that question, how people who fall between these refugee and migrant definitions, well, they're usually defined as migrants, but the question, I think, is how migrants who are in need of protection, though not necessarily refugee protection, access that protection. And that, to me, is the biggest question remaining after these discussions and the adoption of the two compacts. I think it's totally unresolved. I think what you can say is that the compacts have established a more conducive atmosphere and set of mechanisms for international cooperation. And I think the crises of 2015, 2014, 15, 16 sharpened the focus on the need for international cooperation, where even the Europeans realize that they can't do this alone, that they need the cooperation of origin countries, they need the cooperation of countries of transit, they need the cooperation of the Libyan Coast Guard, but they need the cooperation of also IOM and UNHCR, whose turf battles have calmed down a lot since the adoption of the global compacts, but particularly since, I think, a change of leadership at IOM and the very bad experience in Bangladesh, where IOM rushed into a clear refugee situation as the lead agency and has paid a penalty for that. So there is now a letter of broad cooperation, as I'm sure you know, between the two agencies. They have a joint platform on Venezuela. They now have a joint operation in Bangladesh. So I think that that the cooperation between them will produce better results. I think, though, primarily for refugees. I think migrants, and particularly labor migrants, have seen some improvements in things like attempts to drive out some of the abuses from the recruitment system, which is often very exploitative. the Gulf countries, some of the Gulf countries have become much more amenable to migrant protections, doing away with things like the sponsorship system and putting in place more protections. But boy, there's still a lot to be done. And the question of Iraqi refugees waiting in Turkey, and indeed some of those doubly displaced. First they went to Syria, which turned out to be a bad choice. Last time I was in Syria, it was in fact just months before the war started, and looking at the situation of Iraqi refugees in Syria. They're going to be waiting for a long time for a durable solution, I think. Quite a number have gone back to Iraq as the sort of best out of a bad set of options. But I think the chances of their being resettled or getting access to some of these complementary pathways is, I'm not very optimistic about.
David, I want to go to you and then we'll go to Mary.
Sure. So on this classic question of mixed flows, intellectually, the fundamental problem is that people move on a continuum of coercion. And for some people, movement is completely voluntary. They have a menu of options. Whether they move or not doesn't affect anything that's vitally important. And then you have other people that, on the other opposite of the pole, may be killed if they don't move. They might have an option, but the option is literally do or die. And there's continuous variation, whereas these legal categories are categorical distinctions, and they force people into an either or. And that's one of the reasons why around the world you see a proliferation of more categorical distinctions of complementary protection and so forth. They still don't fundamentally get away from that problem, and I don't know that they ever could. And even within these distinctions, you have the different standards. Do you have a credible fear of persecution? Is the likelihood of persecution if you're returned, is that more likely than not? Is that 51% or higher? And tens of thousands of people's lives depend on that standard. Is it 49 or is it 51%? Which is obviously absurd, but that's what you get in these landmark court cases. So, that's a fundamental intellectual problem that leads me to get away from this idea that there's a separate class of human beings called forced migrants that's totally separate from people who move for other reasons. There is that continuum. To answer Claire's question about is the U.S. Now adopting Australia's policies, and if you go back and look at the policy history, there's a lot of give and take. There's a lot of diffusion around these policies in both directions. If you're thinking about Australia, the U.S. And I think the fact that you have a U.S. president who wanted to make it impossible for people who crossed the southern border to ask for asylum, and that didn't work. But that highlights a really important distinction between the U.S. and Australia, which is the very strong rights of territorial personhood in this country, which are based in the U.S. Constitution, and the fact that there is no such Bill of Rights in Australia. So no strong territorial rights of personhood, very weak judicial oversight relative to the U.S. and some other cases. You can also see that distinction when it comes to the way that people who've been intercepted at sea are handled by the government. When the U.S. intercepts people in international waters and takes them to Guantanamo and then repatriates them to their country of origin, which could be very distant, such as China, U.S. aircraft will not touch down in a place where the Immigration and Nationality Act applies. It will not stop for fuel in Hawaii, for example, to make it impossible for someone to ask for asylum. They'll go to places like Wake Island or Tinian and in these territories that the U.S. has where the INA does not apply. Whereas the Australian government is quite happy to take people who have been given the scarlet letter of irregular maritime arrival and have them transit Australia for various purposes.
I was struck by the question, is the U.S. Going to adopt an Australian system? Because in fact, Australia adopted the U.S. system first, the Guantanamo system, which became the Christmas Island system, which, became the Nauru and Manus Island system. So, as David says, there's a lot of mutual learning or race to the bottom. If you,
And I talk about that history in the book, but on that particular issue of Australia learning from the U.S., for better or for worse, the new book by Daniel Gezelbash is just fantastic on that, based on interviews with policymakers who talk about exactly how that diffusion happened.
For those interested happening on Asylum, recommend join us on Tuesday afternoon at 4 o'clock. We're gonna have a specific discussion with Mexican and U.S. analysts talking about what's going on actually and what's going on in terms of management. So
I just pulled up the most recent figures for Iraqi admissions to the U.S. from Department of State, and under the Special Immigrant Visa Arrivals, we assist Iraqis who assisted the U.S. during the war, and we've admitted, it looks like 88 people from Iraq this year. It's shocking, particularly because this is a group of people who had working with the U.S. government, vetted by the U.S. government, and continue to be hung up in the background checks and other sort of machinations that are going on to stem the flow. So even groups like that who are often processed through the refugee program but have specific connections and specific laws that protect them are being harmed by this general, restriction. So.
I think it's particularly shocking given that the origins of the 1980 Refugee Act were in the Vietnam War, when we, accepted hundreds of thousands of people who'd been only very loosely associated with the U.S. And now people who work directly for U.S. military or military contractors or NGOs. 88, that is really scandalous.
there were a lot of hands up, so we're gonna go back to do a final round. We'll take as many as we can. We'll start right here. We'll go over here.
Hi, my name's Annie Wilson. I'm with Islamic Relief USA. And in recent conversations with Islamic Relief field offices around the world, I think we're seeing a trend of, which, won't surprise anybody here, of just more and more sectarian tension and more difficulty in, sort of operating as an Islamic organization or to assist people of the Muslim faith. I'm sort of interested in hearing from any of you how much specifically, Muslims as a refugees population, as an asylum-seeking population, and the security concerns that states have or express about Muslims, have sort of shaped some of what we've seen in these recent developments in the U.S. and around the world. I mean, even to the point where I think, we heard about prayer rugs being left at the U.S.-Mexico border by participants in the caravans, if I'm not mistaken. So, it's kind of used as a red flag and a way of sort of marshaling public opinion in favor of some of these more restrictive practices that we've seen recently.
Over here, we had two hands up.
Thank you. Ashley Benetti. I'm with Georgetown Law's Human Rights Institute. And my question relates to something that, Kathleen, that you mentioned about the Refugee Compact, and that it's a result, or that in effect it encourages or facilitates host countries to keep refugees. And in it, when it defines responsibility sharing, it says that it's based on national interest and abilities of the state, whether it's by hosting refugees or by providing financial resources. And I'm wondering what your opinion is on whether we can reconcile this with it being in the spirit of responsibility sharing and international solidarity. Should states be able to buy their way out of hosting refugees? And I'm thinking in particular with what we've seen in the EU with the potential solutions that have been proposed to the Dublin disaster, whereby states have said, oh, we'll just give more money to the states receiving the brunt of refugees. And states like Italy are saying, well, we're tired of being the bloc's refugee camp. So is it true responsibility sharing?
And this gentleman here.
Hi, my name's open, but my question specifically is to Mary regarding the credible fear and the affirmative backlog. You'd mentioned that the pull of credible fear receipts kind of pulls away from the ability to deal with the affirmative backlog. And my question is, if you could propose either a statute to Congress or some sort of way of solving that problem, how would you go about managing, given the political realities of today, hugely differing political opinions of what it should look like, but what is the middle ground to actually try to fix the balance between credible fear receipts, reasonable fear receipts, with the IJ or the immigration judge backlogs, and all of that to the best extent?
Final hand we'll take is back there.
Hi, I'm Yael Shacher. I work at Refugees International. It's actually a related question. It's about the credible fear. And I was just wondering, kind of relatedly, if, Mary, you could speak to a little bit about the history. So when it was set up, my understanding is it was set up in 1996. And is the crisis that we now have with credible fear a result of the Central American children? Did it start in like 2012, 2013, 2014 when we had unaccompanied minors coming, and its intersection with the TVPRA, and did that create the kind of problem? The reason I ask is because it relates to how you would fix it. If it's because there are now so many families asking for asylum and requiring credible fear. So before 2012, was that the problem? Was there? So is this new? Why is it? What's the change that has created this problem?
We're going to start with Mary in a second, but let me read two questions that we've had come across the wires. One from Naoko at the University of Sussex, who asks, as for the Global Compact, either on refugees or migrants, what novelty does it contain or represent? All the items contained in either of the Global Compacts appear to me simply to be a compilation or rephrasing of the previous efforts already proposed or tried over the past 20 years. And we also have from Karina Draper, who works at a faith-based organization, who says, would like to know how NGOs and FBOs, faith-based organizations and NGOs, can be better activists in the current situation, and if there's been any impact by the work that FBOs and NGOs are doing so far. So Mary, take whatever of all these many questions, some of them directed at you, and whatever you want to take.
Well, I think to start by addressing Annie's question, I'm trying to quickly pull up the statistics, but I'm not succeeding very well. The numbers with respect to admissions of Muslims to the U.S. have dropped precipitously. In fact, both Muslims, Muslim majority countries, Christians in countries where they are religious minorities, Yazidis, a range of folks who may be experiencing persecution based on religion, as well as folks who are fleeing the Syrian war and fleeing other crises. There's just been a precipitous drop across the board, and it's obviously affected people of the Muslim faith significantly, because that's where so many of the crisis countries are. And it's very difficult, even with the sort of sanitized version of Executive Order Number 3 on the Muslim ban. There's no question that was the animus, and it I think really then has just fed into, again, this whole narrative that refugees are risky, they're unsafe, they look at where these people are coming from. You've heard it, I don't need to repeat it. But that then does shape the message. And what I think is hopeful, of course, is that people responded in droves, at the airports in the first days of the ban, and people have continued to come forward and say, we want to resettle refugees, we want them to be parts of our community, and have really pushed back in a variety of ways that I think have been helpful. Frankly, in fiscal year 2018, we didn't know if we would even get to 45,000 as a cap. There were people in the administration who were pushing for 25, 20, even potentially less. So I think the impact that people have in terms of continuing to push and continuing to say we welcome refugees is having an influence. And I think it's definitely also, you can see sort of a shift between this Congress and the immediate past Congress, there's a lot more interest and activity. We're getting a much stronger sort of refugee caucus going. We're getting more bills right out of the gate that are trying to address various aspects of the refugee of crisis, and really, there's even a no ban bill that is really trying to address the specific issues that were, addressed in those early executive orders. So it's clear that it has made a huge difference. It's also clear that Americans have pushed back against that. To turn to the expedited removal questions, I think I'm a big believer that expedited removal is really a useless program. Now, many people within DHS will disagree with you, and we used to have a lot of fights about this, because I would say expedited removal is not working, and various folks in the more enforcement side of the house would say, oh, it's working fine. It's that pesky credible fear that slows us down. And the issue is that, and I still remember, and this was long, long ago, sitting in an office with two Border Patrol agents, early DHS days, saying, you know what? We think that we might be able to use this expedited removal thing along the border more. And over time, it just developed as part of a real sort of a consequence delivery system that CBP really put into full force in 2011. It really developed as an answer, as a response to being able to manage their case flows significantly. And one of the critiques that I always have had of DHS, and including when I was in it, was that the organization does not think through the impact that, say, if one agency is creating a certain set of policies, how that plays out across the rest of the agency. And that was so clear in the context of what an extreme and expanding use of expedited removal does to the protection mechanisms. Nobody back when they created when they created the whole process and the regulatory framework for credible fear, and for that matter, for reasonable fear under the Torture Convention, imagined that it would ever take up this much time, space, usage, because it was a very limited program, limited to ports of entry. And although Congress gave the president the authority to expand it, I think there was a great deal of resistance to that early on, because it was so kind of antithetical to the idea of people getting a day in court, and it should be extremely limited in how we used it. So I think, it's a tool of expediency gone wrong. And if it weren't in place, perhaps we would have spent more time in the last few years learning from the surges at the border to expand the ports of entry and make them places where it's much easier to house and process more people, create more shelters and other sort of short-term care facilities while you're moving families into whatever their next step is, doing things that sort of reframe the fact that we know that our migration flows have changed dramatically, and we aren't putting the money and time and energy into managing that in a way. And although there's a lot of lip service to the idea of, treating this as a regional solution, and that we need regional responses, we aren't necessarily providing the tools in the right way to the right people who could really help to stabilize the countries. And there are experts on this sitting here with me, so I won't go into it further. But I think it has to be a big picture solution. It has to be a regional solution. But in terms of our enforcement structure, we simply can't use expedited removal the way we use it. We knew that those people, most of those women and the unaccompanied, well, not the unaccompanied kids, but most of those families were going to get credible fear because they were raising claims that fell squarely within the possibility of asylum. And so the argument was, why go through the exercise of putting them in credible fear? Why not just move them right into immigration courts? Yes, the immigration courts are backlogged. Yes, there are problems that need to be dealt with there. But when you're looking at where the sort of systemic problems are, I think one of the critical ones is that we have overused expedited removal. We are now seeing that the manipulation of asylum law is really about claiming that this is a loophole. And so we run the risk of people trying to find ways to circumvent it, as this administration has. So I think we have to if not eliminate it, curtail its use significantly and move back into a structure where immigration courts have more of the ability to adjudicate, or transfer cases to affirmative asylum programs so that so that people can, have the ability to raise their claim in the appropriate setting. And if we do that well and we resource it well, then we will hopefully eventually get to a place where people who have a claim will be given given the answers quickly. People who don't have a claim will be able to find a way to go home. The other side of that, though, is that in thinking about all this, we also have to think about a removal system that is not punitive, but is instead sort of more of a social work-based model. We are a long way from getting there, but quite frankly, if we aren't better about when we make a decision that someone isn't entitled to be here, we have to think about the ways to facilitate return in ways that are much more humane and much more based on thinking about helping them to integrate back into the country. So it's got to be all those pieces, I think.
Before I go to Kathleen, let me say that Doris Meisner has put out a proposal on how to deal with the asylum system. In fact, came out with Sarah Pierce, our colleague. They did a commentary that talks about it last week, so you can find it easily on our website, or you can look for Doris Meisner in the Washington Post. She did an op-ed about 2 weeks ago about how we could actually, by transferring, not actually transferring the affirmative system, but using trained asylum officers instead of sending everything to the immigration courts, we could actually get control of the backlog and actually have a system that makes decisions, again, in the kind of timely way that is needed for people seeking protection, but also as a deterrent for people who are using, who do not have as strong claims. So I strongly encourage you to look for that. So Google Doris Meisner, Washington Post, or look for Sarah Pierce and Doris Meisner's commentary from last week.
Just very quickly on two of these questions. Should states be able to buy their way out of responsibility sharing? No. But it's better than nothing. Money is better than nothing. If states are not going to do anything else, at least they should contribute.
Real politica.
Yeah, okay. You look at things like the EU Trust Fund for Africa, pretending that development can be a sort of cure for migration is sort of specious, but again, it's better, probably better than nothing. And again, very quickly, how can NGOs and faith-based organizations be more effective? Very specific answer. Read my colleague Natalia Bănănescu-Bogdan's paper on messaging about migration. It's called When Facts Don't Matter. And it's an excellent sort of deep dive into how organizations and individuals can counter the very negative narratives about migration and refugees through careful messaging, not by preaching, by personalizing contact with refugees and migrants and sort of putting a human face on the problem. That's a totally inadequate summary of Natalia's paper, but I recommend it very highly.
And David, great to have you here. Give us the final words for this session. I realize we're running a couple of minutes over, but you've got the last word here.
Sure. So just a couple of points responding to the question first about NGOs. And especially when it comes to activities in buffer states and activities in the moat, these kinds of maritime interceptions, we see the critical role of NGOs as watchdogs. And we also see governments trying very hard to eliminate NGOs from those spaces, whether it's what Orban has done in Hungary or what the European Union, particularly the Italian government, has done in the central Mediterranean to try to prevent NGO boats from operating in those spaces. But what gave me some hope when writing this book, it's not a very cheery book, but what did give me some hope was that again and again and again, when I looked at landmark cases like the Hirsi case that I referred to from the European Court of Human Rights, some of the key court cases around Haitians seeking asylum in the 1990s, you see that reports from Amnesty International and local NGOs, investigative journalists, also the U.S. State Department human rights reports, you see those cited in the landmark court cases as evidence for why people cannot be returned. Remember that the judge sitting in Miami doesn't have the authority or the capacity to go out and collect facts on the ground. That requires this quiet, peaceful army of advocates, of researchers, of people paying attention. And it gets back to the old idea of Doctors Without Borders, of témoignage, right, of testimony. And the idea is not simply testifying about atrocities after they happen, but the idea that by having more independent eyes and ears on the ground, that reduces the kinds of atrocities that generate refugee flows in the first place. So that's one of the positive messages that came out of this.
Thank you to our panelists, and thank you to all of you for being here. And a round of applause. It was a great conversation.